So let's talk about self-defense with assault cases. One of my favorite cases of all time, the guy actually shot the victim 5 times, including in the eyeball. The guy lived by a miracle, and about 6 months later, we had a case where he was testifying at the preliminary hearing. At the hearing, I asked him, "Did you pull out a knife on my client before he shot you?" And the answer was no, 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 no. But I asked him so many different ways and so many different times. Actually, we went to his priest, and the priest told me you have to tell the truth. The guy's sentence, my client, went down from 25 years to life, which means he could have spent the rest of his life in jail, prison. It went down to 3 years. He had almost credit for time served. So when we look at self-defense crimes, their key was the other side, who's now being called the victim by the police officers. Was that person the actual aggressor? Did you use the proper amount of force in defending against the thing that was coming at you? And if we can prove that you were defending yourself, you can walk away not convicted of a crime completely. So one of the questions we get asked is, does California have a stand your ground law? We rephrase that a little bit. So in a self-defense claim, you have the right to defend yourself. You don't have to flee an assailant. You don't have to run away from somebody. You can stand your ground. The key is, if somebody is using non-deadly force against you, you use non-deadly force against them. If somebody is threatening your life with a knife, a gun, or if they're specially trained, you can use deadly force to defend yourself. You don't have to flee. You shouldn't flee, frankly, because you're more likely to get hurt when you're running away. So you have every right to stand your ground in California. The key fact with self-defense is you can't use force in excess of what the other person is using. If a 2-year-old comes at you and tackles you, obviously you don't want to use excessive force. That'd be horrible. So instead, what you want to do is make sure if someone's coming at you and they're unarmed, you shouldn't use a weapon. You should use whatever techniques you can to defend yourself, but you can't shoot somebody who's running at you without a weapon. In the same way, law enforcement officers, we've represented a few over the years, law enforcement officers don't use deadly force unless deadly force is coming at them. However, you should know that under the law, even a person 30 feet away with a knife is threatening you and your life, because it doesn't take all that long for that knife to be thrown or run toward you and stabbed. So just remember, you have every right to defend yourself. If someone's coming at you, armed especially, and even if they're not armed, you have a right to defend yourself. If possible, obviously avoid, but if you can't avoid, stand your ground, defend yourself. And if you get caught doing something the police think you shouldn't have done, give us a call at Strongest Defense and we'll take care of it for you. So when we're looking at assault crimes, whether it's a felony or a misdemeanor, and by the way, some people don't know what the difference is. A felony has some further lifelong consequences, like you can spend time in prison, you can actually spend more than a year in custody. As a misdemeanor is anything where the time in custody is a year or less. A felony is usually defined by either the amount of force used or the injury inflicted. If the force used leaves serious marks, cuts, loss of consciousness, significant loss of blood, things like that, it's more likely to be a felony. If instead you have minor aches and pains, maybe a bruise or two, we're more likely to get that down to a misdemeanor. One of the things that comes up in assault cases that we hear from our clients is, but I didn't try to do that. I didn't have the intent to do that. And frankly, assault with a deadly weapon charges, for example, the definition of assault is one of the hardest laws to explain to jurors because it's just a bunch of legal gobbledygook. So frankly, intent doesn't always matter. It matters with murder charges. It matters with cases with great bodily injury sometimes. But for the most part, your intent doesn't matter. I didn't mean to hit her that hard. Intent doesn't really matter as much. What does matter is the outcome, the actual physical effects or sometimes the circumstances where you were defending yourself or whether you were the actual aggressor. So when you're charged with a felony assault crime and you don't want that to occur, you want that to be a misdemeanor, kind of aggravated being a felony, simple being a misdemeanor. What we do is we try and show the jury or the judge or the prosecutor what was behind your actions, what you were thinking, what stresses you might have been suffering from. Sometimes mental illness comes into play. We use anything we can to help get that felony assault charge reduced to a misdemeanor if at all possible. And if we can't get it reduced and there's a valid defense claim, that's what we'll do. We'll try and use self-defense to mitigate the crime. So if you've been arrested for any type of assault crime, don't spend your time worrying about this. Give us a call at Strongest Defense. We want to help you through the process. We want to defend your rights. We want to make sure that you can defend yourself properly, just like you did on the street the day of your arrest.